Yes.
My lady, my lords, I'll try and cut my cloth accordingly, and I'll begin with the facts that we say are essential. I will then go on to ground 1. I'll then take grounds 2, 3 and 4 together, because as your lordship identified in giving permission, there is overlap there. Then very briefly, 5 and the respondent's notice. On the findings of fact, could we please go to page 78 of the core bundle, or A524?
Yeah.
And this is paragraph 106 of the judgment, and we say this contains perhaps the judge's most significant findings of fact. He finds that Mr. Higgs and Mr. Morris were patently honest and careful witnesses. He finds that they both believed the intention in 2012 had been for comprehensive insurance cover, creating a fund of sole recourse. Now, obviously, neither Mr. Higgs nor Mr. Morris quoted Guard Marine or said anything about a fund of sole recourse. So what the judge is accepting is their evidence as recited at paragraphs 96, 102 and 109 of the judgment.
Yeah.
And if we could go to those, please. First, paragraph 96. Which
Well, we've read these. So unless there's some particular point, but we've read these and we understand that that's their evidence. The judge didn't draw the adverse inference, but concluded, as you pointed out, at 106.
Yes, my lord. So we say his finding was that Richard Knight, the RFU's stadium director, had told Mr. Higgs that insurance was being obtained, and he hoped it would lead to a reduction in tender prices, which is paragraph 96. We say he found that what Mr. Morris has recorded as saying at paragraph 102 is truthful and factual, that Mr. Morris had been told that there would be project insurance to cover all contractors and avoid claims between them. And over the page at page 77, the bottom half of paragraph 102, that it had been agreed that Conway would provide cover only until the RFU put their own cover in place, and that Conway had not included anything for insurance in the tender or obtained its own insurance. Mm-hmm. We say the judge accepted that this is what happened as a matter of fact in 2012. He says at paragraph 106 that this was not only their honest belief in trial in 2022, but an accurate reflection of what they understood and believed in 2012. Mm-hmm. If we look at paragraph 100, we see the judge reciting some of the relevant email chains in early July 2012. Now, early July obviously is 3 weeks after the letter of intent and 2 weeks before the inception of the project policy. One of the emails noted by the judge is from Mr. Higgs to the insurance broker and Mr. Knight. Mr. Knight, of course, is the RFU stadium director. He's the gentleman that, on the judge's findings, told Mr. Higgs that he hoped stadium-wide.
So where's this?
So, my lord, paragraph 100.
Yeah.
In early July, Mr. Higgs began pressing for project insurance.
Yeah.
4 lines down, this prompted Mr. Higgs to explain in somewhat exasperated tones that the issue was nothing to do with startup insurance. He asked for insurance to be put in place immediately. Yeah. Otherwise, I'm going to have to ask Conway to provide their own insurance. Yeah. So this is 3 weeks after the letter of intent, 2 weeks before the policy. Mr. Higgs is emailing a director of the RFU and the broker and saying, we need to get this in place, otherwise I'm going to have to ask Conway to put their own insurance in place. The director that he's emailing, Mr. Knight, is the gentleman that the judge had found, had told Mr. Higgs that he hoped procuring project-wide insurance would lead to the insurers removing insurance from their tenders. That was the finding at paragraph 96.
Yeah.
Now, there is no, the email is in the unagreed bundle. The email itself is in the unagreed bundle. I won't go to it, but there is no response from Mr. Higgs.
Can any of this get any better for you than the findings in 106?
Well, I just want to. It can't, my lord. You're absolutely right. But what I wish to do, and if it's a waste of time, tell me that it's a waste of time. But what I wish to do was identify the ingredients of authority and intention that the judge found to be.
But the judge found those, as I understand it, because he said they both believed that the intention had been for comprehensive insurance cover, blah de blah, at 106.
But it isn't just a matter of them both believing that, my lord. What the judge is finding, we say at 106, in finding that they're honest witnesses, in finding that they believe this, what he's finding is that what they stated about what they stated was true, and what they stated was not just a matter of what they believed. It was a matter of what they had communicated to each other.
Well, are you going beyond 106 then?
No, my lord.
Right, well, if you're not, then I don't need to look at anything else, do I?
So
you've got to get around 107 and 108, haven't you? That's
the next point. But just on this question of fact, we can't have island hopping.
So
this isn't a family case. So we can't have we can't have island hopping. We can't look at little bits and snippets. That's why I asked you whether 106 was as good as it got, because he makes the findings as set out there, which is, you say, I know there's a dispute about this, but you say that's the culmination of what he found from 94, effectively 94
exactly.
onwards. I understand that.
But what he found at
what he found is what is set out in these paragraphs.
Yes, it is, my lord. I don't intend to go beyond that one inch.
Good.
But the point is that, as we saw in Magellan Spirit, subjective, uncommunicated intention doesn't get you anywhere. That's the point. So what I'm trying to establish, the point I'm trying to make, is that 106 is the culmination of his earlier findings, and his earlier findings in these specific paragraphs are not just about subjective intention, they are about what was communicated between the two parties. And that is what's relevant, what was communicated between the two parties.
Well, then I think there is a potential problem. If you can show me where, if communication becomes important, you'll have to show me the findings he made about communication.
So this is what I was endeavouring to do, my lord. So
well, 100 talks about email exchanges, which he doesn't set out.
So no. So the email, the relevant content of the email exchange is set out in 100. So in 100, this is an email that is
Oh, fine.
sent.
The bit you've shown us.
Yes,
Fine.
yes.
Okay.
That's all.
So you say that's communication.
That's all I'm relying on.
Right. So you don't need to look at the email. Now,
I don't.
We need to make progress. Come on.
So
right.
Paragraph 100. What the judge's finding occurred here is that Mr. Higgs sends this email saying, "I am going to have to ask Conway to provide their own insurance unless you put this in place." We then see there is a meeting on the 4th of July, the startup meeting, which is attended not just by Mr. Higgs and Mr. Morris, but by various directors of
was attended by representatives of Conway, the RFU, and
Yes,
others. Yeah.
various representatives of both.
Yeah.
And at this meeting, what is recorded, what has been communicated, and what is recorded as being said at this meeting is the intention is to establish stadium work insurance, although this would not cover plant work, equipment, and welfare. But this has not yet been achieved. Conway were asked to put insurance, were asked to ensure they provided cover for the works. Once the project insurance is established, Conway will be notified and claims will need to be made to Marsh. Now, there was a meeting at which, as between the two sides, the RFU and Conway, was communicated the intention to procure project-wide insurance covering the works. At that meeting, they specifically identified what the exceptions to the cover would be, and you can see them specifically identifying what the exceptions to the cover would be. It would not cover plant, equipment, and welfare. Now, those are exclusions that one sees in the policy itself. The policy expressly does not cover plant, equipment, and welfare. What the judge is finding here, what he's saying here, is that 2 weeks before the works commenced, the parties stood facing each other, not just Mr. Higgs and Mr. Morris, and said to each other that the intention is to procure this stadium-wide insurance, and the exclusions from the stadium-wide insurance are limited to these matters. Now, we say, my lord, that represents the communication of intention by the Rugby Football Union. They are telling Conway in direct terms what they intend to do, and it represents the communication of authority by Conway, because Conway is saying
none of this is in your skeleton argument.
It is, my lord.
Not points by reference to minutes of meeting.
It is, my lord.
Okay.
It is.
Well, at some stage we'll go to the skeleton argument because we need to look at the grounds
Yes.
of appeal, which we're so far ignoring. All right. So you say these are the exclusions. We can find them in the policy.
Yes. And we say that the communication happened on communication of the relevant authority and intention happened on multiple occasions. It happened when Mr. Higgs said to Mr. Morris that's what they would be doing. It happened when and that the RFU didn't need to procure insurance. It happened when Mr. Morris said to Mr. Higgs, we're not going to charge you for insurance and you can procure this policy on our behalf. It happened again at this meeting. That was the communication of authority and intention very shortly before the policy was incepted. Now, if I go now to ground one, ground one boils down.
Before we do that, we've gone up to 106.
To 106, yes.
And then there are a number of other mixed findings of fact and law from 107 onwards.
Certainly, my lord. And
I'm not inviting you to go through each of them, but my lord's question was, well, don't you have to get round, for example, 107 and 108?
So, in my submission, my lord, 107 goes nowhere, and 108 is actually helpful to us. So the reason 107 goes nowhere is that the exercise that the judge is conducting in 107 is a legally irrelevant exercise. The comparison of Mr. Higgs and Mr. Morris's subjective intention to what the contract documents provide is irrelevant. No one cares what Mr. Higgs and Mr. Morris's subjective intention was. It's what was communicated between the two of them that matters. And the exercise of comparing their subjective intention to what the documents provide is doubly irrelevant. It's irrelevant because no one cares what they think, and it's irrelevant because the judge has already decided that as a matter of law, the contract trumps everything. And so whatever he finds they intended, whatever he finds they communicated, he's going to find, on the application of the principles of law that he identifies, that it's irrelevant.
Okay.
So that's why we say 107 goes nowhere. 108, now, at first glance, that might seem to go somewhere. But on analysis, it doesn't. And it doesn't because the relevant finding that the judge makes, we say, is in the last sentence of 108. The last sentence of 108 is that this is not a case where the contractually effective dealings were conducted solely or indeed principally through Mr. Higgs and Mr. Morris. So the judge appears to be accepting that contractually effective dealings were conducted through Mr. Higgs and Mr. Morris. He appears to be accepting that Mr. Higgs was authorised to conduct contractually effective dealings on behalf of the RFU, which makes complete sense because he's the project manager for the tender, and he appears to accept that Mr. Morris was entitled to conduct contractually effective dealings on behalf of Conway.
I don't understand that. You're saying the opposite. This is not a case where the contractually effective dealings were conducted solely or indeed principally through Mr. Higgs and Mr. Morris.
Solely or principally is what he's saying. He's very specific.
They were largely irrelevant to the contractually effective dealings. Rather, the terms were agreed between teams of a number of professionals on each side.
And responsibility for the insurance arrangements was, as Mr. Higgs accepted, in the hands of Mr. Pettifer.
So again, let's break that down. The insurance arrangements, look, on any project of any scale, contractually effective dealings are not going to be conducted through two people. One does not eliminate the contractually effective dealings that were conducted between those two people on the basis that there were contractually effective dealings between other people too.
He makes no finding that there were any contractually effective dealings through Mr. Higgs and Mr. Morris.
Well,
He's saying this is not a case where the contractually effective dealings were conducted solely or indeed principally through Mr. Higgs and Mr. Morris.
But he's not saying that no contractually effective dealings were conducted.
We can't construe the judgment as if it's a chancery will.
He's saying they were not.
I'm unaware of any finding that they were involved in any way in the contractual negotiations.
Mr. Gully, you've got to read that one sentence which you're relying on in the context of the entire paragraph. And the entire paragraph begins, the parties were substantial entities dealing at arm's length. And then he goes on to expand on that. And it is in that context that there is one sentence where, speaking for myself, I don't agree with your interpretation of it. But it is in that context.
So, my lady, there is no project in which contractually effective dealings will be conducted solely or principally between one party on one. No project of any scale where that will happen. So that standard is not a relevant standard. The fact that Mr. Higgs was not responsible for procuring the insurance is not a relevant matter, because the question of procuring the insurance.
Where do you get the word procuring? Sorry to interrupt you. And that's not the word is responsible. The sentence I picked up, we're all picking up different sentences from this paragraph, which probably isn't helpful. But accepted responsibility for the insurance arrangements was on behalf of the RFU, it was on the hands of Mr. Pettifer. So it doesn't say procuring. It's more than it's. The law's right. We can't interpret this document. The judge isn't saying responsibility for procuring the insurance arrangements, Mr. Pettifer. He's saying responsibility for the insurance arrangements.
Even if that is the case, my lord, even if that is the case, the very specific area that we are looking at here is what happened during the tender process. What was agreed during.
We're looking for authority, aren't we?
We're looking for
how would you put it? What are we looking for? Authority.
So on the primary case, we're looking for my primary case that Conway has identified. We're looking only for authority.
Right.
And if we're looking only for authority, then the question of whether or not contractually effective dealings occurred between Mr. Higgs and Mr. Morris is irrelevant, because authority, the agency is not.
Okay.
It's not a contractual.
This is on your second. It's relevant to your second case.
Sorry, my lord.
This is relevant to your secondary case.
It's relevant. It's relevant to.
Okay.
It's relevant to both cases.
This is your case that agency trumps all.
It's
I made a note in red this morning. Your case now, at any rate, is that agency trumps all, and that if you're right about the identification point, really, other than possibly authority, we don't care about anything else other than the policy. So I understand that, and so that's why you say both 107 and 108 are irrelevant.
Well, we say they're irrelevant on the primary and alternative cases, my lord, because
Which both cases rely on agency.
both cases
You
rely
can
on.
say yes sometimes, Mr. Garley.
Yes, my lord. Yes. Their agency is not necessarily a contractual relationship.
Yeah.
There's no requirement for there to be contractually effective dealings.
You said paragraph 108 helps you, so you put it. 107 is irrelevant, and 108 helps you. So in a sentence, how does 108 help you?
The basis on which I was positing that 108 helps me is not going to be accepted by the court. But what I was positing was that what is being said in the final paragraph is that there were some contractually effective dealings between the parties. So even if that were the standard contractually effective dealings,
we understand
that there could have been contractually effective dealings between them. But I won't persist in. I see the way the wind flows, and I won't persist in that. I won't persist in that point. But in any event, we say the question of whether or not there were contractually effective dealings, it's irrelevant on the agency analysis, because you don't need a contract for an agency relationship. If I may, I'll move on to ground one, and I'll try and take ground one very quickly because we've already looked at the authorities. Ground one boils down to the following three complaints. First, Guard Marine does not say what the judge interprets it as saying. It does not say that the terms of the underlying contract between co-insured provide the key to the existence and extent of insurance cover. It doesn't say that.
That's the point you made this morning.
Yep. And it doesn't say that the scope of the insurance cover is circumscribed or determined by the underlying contract. So to the extent that the judge relies on Guard Marine or co-op to cut down the insurance obligations, then that's not what those cases say. It's not what those cases do. And we also say that by requiring Conway to demonstrate an intention to create a fund of sole recourse in order to show that they were co-insured or benefited from the co-insured defence, he was imposing a standard that does not apply. Conway doesn't need to show that. Conway only needs to show that they are co-insured. If it shows they are co-insured in respect of the relevant risk, the court should imply a term precluding a subrogated claim, on any analysis, a subrogated claim between the two. That has been the law for 40 years. The only questioning of whether that might be correct is the obiter of Lord Justice Ricks in Tycho Fire. But that is out of line with, we say, every other case where, in most cases, the point is not even argued. It's not argued that there can be a subrogated claim between two co-insured. That's ground one. We've seen the authorities.
You said there was a third point. I've got Guard Marine doesn't say what the judge said it did, and you say that the judge was wrong to require Conway to show that there was a fund sole recourse to which would be the only route, and you say all Conway had to do was to show they were co-insured.
The third point really, it's a facet of the first point, which is the implied term point that the judge is making about the difficulty of implying a term into a first he says that
you say that's not difficult because if you're right and this is similar to co-op, they did it in co-op.
If we're co-insured full stop, you can imply a term. There is no difficulty in implying a term that prevents subrogated claims. Not only did they
So
do
that
it
comes back to the second point, co-insured.
Taking grounds 2, 3 and 4 together, all three...
Well, I'm going to make my note, if you don't mind, I'm going to make my notes under the separate heads. Ground 2 is the building contract point.
So ground 2 is simply that. We say two things about the subsequent building contract. We say that you don't construe the policy by reference to the subsequent building contract, and we say that while the subsequent building contract can potentially have some evidential value in demonstrating whether authority and intention had been communicated as at the 17th of July 2012, very little weight should be placed on a contract that was entered into 3 months later in circumstances where A, the contract does not, the JCT form does not restrict the insurance that the RFU is to obtain. It doesn't say this is a maximum level of insurance, and consequently...
It says not less than.
Not less than.
So that's the not less than point.
So,
but you accept, I think, that option C would not cover.
Yeah.
And let me be clear, what is it that option C doesn't cover? Insuring against your own default?
So option C does not cover damage to works of other contractors. So this...
Okay, I get you.
As your lordship knows, the form, for what it's worth, was a manifestly inappropriate form for this project. The form is not designed for 22 main contractors working in parallel, and the insurance provisions in the form are not...
But option C was the relevant option because this was works to an existing structure, whereas A and B are new works, new build.
Yes, but there are none of the JCT options cover damage to the works of... None of the JCT options require the insurance of the works of a contractor working in parallel.
Okay, so you accept that it doesn't cover damage to works of other contractors. Your point is it says not less than.
Our point is it says not less than.
And what was the second point about the JCT contract?
The second point is that it's to be accorded little evidential weight because apart from the legal reason why there was no need to amend it, there's a practical human reason, which is the parties have what they want as at the 17th of July. The RFU has a tender from Conway that includes nothing for insurance, so they've achieved what Mr. Knight wanted to achieve, that the insurance cost has been knocked off the tender, and Conway have what they wanted, which is that they have, as far as they understand it, they have insurance that covers them in respect of the whole of the works. So that being the position, there's no reason why business people would take the time and spend the money to go and amend the insurance provisions in a contract that they enter into later if the contract says minimum cover and they've achieved what they wanted to achieve.
Okay, I understand that. So that's the first point about the building contract. Underground 2, what's the second point?
There's nothing else underground.
So that
So we simply...
Yes, okay. What about, you touched on it this morning, I just want to be clear about this. The point about retrospectivity.
So this is the letter of intent and not the contract itself.
Well,
The retrospective effect of the contract.
well, we can't necessarily distinguish them because nobody says that there were any material changes to the contract that was envisaged in the letter of intent and then entered into 3 months later. So in this case, the contract, although dated such and such, has retrospective effect. So is there anything you want to say about that in connection with this appeal?
So we say that the fact that the contract has retrospective effect can't affect the obligations under the policy.
So that's the point you were making this morning.
Yeah, well, I was making 2 points. That was one of them. So we say the retrospective effect can't affect cover under the policy because, as everyone accepts, this is a composite policy which takes effect as separate contracts of insurance between the insurer and each insured. So it's common ground that as at the 17th of July, it's common ground that Conway had its own separate insurance policy with the RFU. A subsequent agreement with it's common ground that as at the 17th, Conway had its own separate policy of insurance with RSA, not the RFU, with RSA. A separate agreement between Conway and the RFU, which is entered into after the event, 3 months after the event, cannot affect the obligations under a composite policy, a separate policy of insurance.
This composite is a word that's come up a couple of times. Do you use composite as opposed to joint?
So they mean different things, my lords. We use both.
Well, I understand that, but hence I'm picking you up on the advent of the word composite into the case. Again, not something I'm conscious of seeing before. You referred to it as a composite policy. Is that in contradistinction to it being a joint policy?
Yes. It's what composite means, and this is covered in the supplemental skeleton, and it's covered in the respondent's notice, my lord. What composite means is that if you have a joint as opposed to a composite policy, and one of the insured commits a relevant breach of that policy, that can void the insurance for everybody because they're all considered to be as one insured. So the misconduct of one can void the other's insurance. Under a composite policy, which everyone agrees this is, they take effect as separate insurance policies. So there's a separate insurance policy as between RSA and Conway as at the 17th of July. And what the RFU does after the 17th of July, or what the RFU and Conway do after the 17th of July, can't affect the content of a distinct policy between Conway and RSA that was incepted on the 17th of July 2012.
Yeah, okay.
The other point that I was making this morning was the point about the effect of the letter of intent and whether one which of the terms one imports into the letter of intent as at the 19th of July 2012. And what I was saying at that point was that one only imports those terms that the contractor needs to adhere to avoid being in breach of the later contract. And I said the authority for that was Twintech. We have obtained multiple copies of Twintech with the court's permission, the parties agree that there's no issue between the parties, we can add that to the bundle overnight if that would be helpful.
Well, fine. I might look at that overnight. So perhaps when we finish this afternoon, that could be provided to the learned usher, but not now.
Oh, certainly, my lord. So, let me take, if I may, I'll take.
So that's ground two. That's all you want to say about ground two.
That's all I want to say about ground two.
So then ground three.
Ground 3 and 4 are, forgive me, best taken together because I need to outline the principles of agency that we say apply, and then distinguish the situation of the named insured from the situation of the situation of the identifiable insured. So with your leave, I will do that. The headline point across both grounds, the headline point that we make is that there is no principle of English law that says the cover of a named insured or the cover of an identifiable insured is limited to the cover that is required under an underlying contract of insurance. I will go in a little while to the passage of Colin Vaux that is in the authorities bundle that sets out the...
Limited to the cover that is required under...
an underlying contract.
Thank you.
I'll go...
Okay, well, so that's the underlying point, yeah.
I'll go to Colin Vaux and show your lordships that if there were this radical a principle, you'd expect to see it in the textbook. It's not there, it's not in the textbook, it's not the law. The situation where the principle for which the respondents contend applies, that applies as a rule only in the case of a principle that is unidentifiable as at the point in time the policy is incepted.
Yeah, well, that's the point you made this morning.
Yes. So if I may, I will set out again what we say that the three categories are before I go to the authorities. We say
I'd be really keen if you stuck to the grounds. I've got to write a judgment that deals with your grounds.
Certainly, my lord.
Not the authorities.
Certainly, my lord.
So that's your headline point across grounds 3 and 4.
That there is no underlying
understand
principle. That. It relates only to a principal who is identifiable as at the time the policy is incepted.
Yeah.
Ground 3, we say that the general rule is that if I contract with Mr. Reed, I should not later find that I have obligations to someone called Mr. Wheater, which are defined in a contract between Mr. Wheater and Mr. Reed that I am not party to. That's the general rule in Maxted and the general rule that Mr. Justice Leggett...
Yes, in paragraph 15.
Precisely, my lord.
Magellan.
In Magellan. Exactly that, my lord. Now, agency, which everyone agrees is the analysis here, agency creates exceptions to that rule. So Party A can think it's contracting with Party B and can find that it has in fact contracted with Party C and its obligations are defined by an agreement between Party B and Party C. That's an exception. Because that is an exception to the general rule, because it offends against the principle of objective interpretation, the law creates various control mechanisms that apply to restrict that violation of the principle of objective interpretation. One of those control mechanisms is the requirement for authority going from the principal to the agency, to the agent. Another of those control mechanisms is the requirement of intention. requirement of intention, that control mechanism demonstrating communicated intention, only applies in the case where the principle is not identified in the policy. And if we could go, please, to Colin Vaux, which is Authorities Bundle 397. Again, this should be, but is not sidelined. And I would ask your lordships to sideline from paragraph 1522 over the page, all the way down to the bottom of 26. Now, what you will not find in this statement of the principles of agency, what you will not find is any rule that says the principles cover is limited to an underlying contractual obligation. You won't find that because it's not the rule for either identified or identifiable agent.
It's traditional when you take the court to an authority to identify for them the proposition that you rely on. Are you referring to this because it doesn't refer?
So I first rely on the absence of the proposition, and then I'll take your lordships to the proposition that I rely on, which is at paragraph 24, which is a demonstration that the primary assured, we accept that it's a necessary ingredient of agency is a demonstration that the primary assured intended to cover the interests of the third party. But we say that in our first case, in our ground 3 identified principle case, that the necessary demonstration of intention is in the policy itself. It's the fact that they have named this party as an insured. That's the only demonstration of intention that you need, the fact that they've named a specific party as insured. One then construes the contract objectively.
So we're back again to the simple fact of co-insurance.
Yes, my lord. Now, if we go over, please, to paragraph 27. And look at the second sentence. That second sentence is Conway's primary and alternative cases expressed in a nutshell. It covers both situations, both Conway's primary and alternative cases.
In 1527?
1527, second sentence, an intermediate situation.
Is that in which B, that's Conway, has authorised A, that's RFU,
Yes.
to insure on his behalf but has not required him to do so?
Yes.
In which case Conway must, if Conway is not listed as an insured person, rely if he can on the undisclosed principle doctrine.
So let's unpack that if we may. So
I have no idea which ground this is.
So this is setting out both grounds. This is grounds 3 and 4, my lord, but compressed into one sentence in this textbook. If
I thought they were alternative cases.
they are alternative cases, my lord, but this sentence covers two situations. This sentence covers two different situations. So if B has authorised A to insure on his behalf, and B is listed as an insured person, so if B has authorised A to insure on his behalf, and B is listed as an insured person, then we are not within the undisclosed principle doctrine.
Yeah.
Normal principles of contractual interpretation apply. Authorisation plus being listed as an insured, you just construe the policy for the extent of cover.
Yeah.
If B has authorised A, but is not listed as an insured person, then he must rely on the undisclosed principle doctrine. So that they are ground 3, ground 4.
Right. Okay, got that.
So that is the principle of law on which we rely on grounds 3 and 4, expressed in the pithiest possible form, but it contains in there all of the propositions that we rely on and all of the propositions that we say are correct. If
1527 of Colombo.
1527, second sentence, contains all the propositions we say are correct. Authority is needed in both cases. Authority is needed whether or not identified, you need authority. But if you are identified, you do not need to rely on the undisclosed principle doctrine, which is a shorthand for saying you do not need to prove intention of the agent. If not identified, you do need to rely on the undisclosed principle doctrine, which is shorthand for saying you do need to prove the communicated intention of the agent. And again, this is contrary, the proposition that we see here is contrary to the case that the RFU advances and the judge's findings below in relation to both grounds 3 and ground 4, because this proposition is not that insurance is circumscribed to the extent of underlying cover. If we look at what is...
If you've already won on ground 1, we wouldn't be dealing with grounds 3 and 4.
So...
Because that's your point under ground 1.
But it's also the point under ground 3 and 4, my lord, because in grounds 3 and 4, the judge is saying, even on the principles of agency, forget about the co-insurance principles, the judge is saying, and the respondents are both saying, that the principles of agency include a rule that cover is circumscribed to the extent of an underlying obligation.
Yeah.
And we say that it's not just that proposition is not present in this section. This proposition is contradicted by what is said here, in which B has authorised but not required him to do so. There's authorisation, but there is no underlying contractual obligation to insure at all in this situation. There may still be cover under the policy, absent any contractual obligation, absent any requirement to insure.
Yeah.
And I want to try and make that good by going to Petrofina, which is in the authorities bundle at page 33, or G21.
Sorry, give me the page again.
33, my lord. So, if I may begin with the facts.
Well, Mr. Garley, on the timetable I gave you, you've got 7 minutes. You haven't dealt with a waiver, you haven't dealt with a respondent's notice. So I'm not sure the facts of yet another complex commercial case are really apposite in that circumstance.
The proposition that we take from Petrofina is there is no requirement for an underlying obligation to insure. And that's clearly seen in Petrofina, because if we go, please, to page 38, and look at letter F, please. And if your lordships read down from F and then over the page, you see described the contract between the subcontractor and the main contractor was a subcontract that contained no obligation of any kind to procure insurance. There was a second subcontractor involved called Mamaway. In the case of that second subcontractor, there was also no contractual obligation to insure. Notwithstanding the fact that there was no obligation to insure in either of these cases, Mr. Justice Lloyd found that both of the subcontractors were insured under the project policy. That's the finding in Petrofina. Two subcontractors, no underlying contractual obligation to insure at all, but they were both insured under a project policy that named as other assured subcontractors. Project policy says the other assured are subcontractors. They fell within that definition, and they were insured despite the absence of any underlying obligation. So we say, my lord, that the proposition that an underlying obligation is required is not good in law. The only situation, and I will deal with this. I'll deal with this very quickly and without taking you to the authorities. The situation where there is a requirement to identify an obligation, an underlying obligation, arises where the principle is unidentifiable as at the time the contract is incepted, and that was the situation in both Haberdasher's Ask and BP and Kvarna. In both those cases, as at the time the policy was incepted, the agent did not know that it wished to insure the subcontractor. The subcontractors hadn't entered into any contractual arrangements with the subcontractors. It didn't know there were going to be subcontractors. They turn up after the contract is incepted. And it's in that situation that the principle that the judge found applies, and the principle for which the contractors, the respondents contend, applies. So ground three in a nutshell, the judge was wrong to find the obligation, that the scope of the insurance was coextensive with the underlying obligation. He should have found that Conway was identified as insured in the policy, and having found that they were identified as insured, there should have been no problem on the basis of his findings of fact, finding that there was authority conferred by Conway The fourth ground, again, the judge was wrong to find that the extent of cover was circumscribed by the extent of an underlying obligation. That does not apply in the situation of an unidentified but identifiable principle. And once one puts that incorrect analysis of the law to one side, on his own findings of fact, there was authority and intention sufficient to establish that Conway participated under the undisclosed principle doctrine. Now, I will. That's it on grounds 3 and 4. Ground 5, your lordships have my skeleton. I'm not going to develop that orally now. So I will finish with the respondents' notices. Now, if we could go please to core bundle 150.
Yeah.
And we look at the definition of insured in the policy.
So this is for each for their respective rights and interests point.
Yes, ma'am.
Yeah.
The respondents say that the words each for their respective rights and interests means to the extent required under an underlying policy, under an underlying contract. That's what they say those words mean. Cover is circumscribed to that extent. Now, they don't mean that.
You tell me what they mean.
They mean two things. They mean that this is a composite policy. That was what General Accident found. That those words denote that this is a composite policy, and each insured is insured as if they had taken out their own separate insurance to the extent of their insurable.
One definition of a composite policy is where the co-insured have different interests.
Yes.
And you accept that?
Yes.
Okay.
Yes. But these words do not. The parties, of course, have different interests under this policy. They, of course, have different interests. But these words do not mean that the extent of cover is cut short.
I'm trying to tease out, in the few moments we have left, what you say they do mean. That's now two submissions you've made about what they don't mean.
Oh.
But what do they mean?
They mean that the contractor must have an insurable interest and is only insured to the extent of their insurable interest, and further that the policy is a composite policy. That's what they mean.
What's the word right doing in that phrase?
So this is why we put quadra in the bundle, because rights are species of insurable interest, and I can show you that.
Okay, so
very quickly.
I'll look at quadra later, but you're saying rights in this context means a species of insurable interest.
Yeah, and my lord, such as the right to immediate possession. That's an insurable interest. If your lordship goes to page 380 of the authorities bundle.
E.g. right to immediate possession. So it doesn't impute any reference to any contractual, it doesn't mean contractual rights, you say?
Yes. It doesn't mean underlying contractual rights. That form of, we've included in the bundle, and we've referred to in our supplemental skeleton, what McGillivray and what Colinvo say those words mean, because they're a very common form of words that have been used repeatedly for 100 years.
Okay.
And neither Colinvo nor McGillivray say they mean to the extent of an underlying contractual obligation. No authority says that. What they say is, both McGillivray and Colinvo say, it denotes a composite policy. And what Mr. Justice Butcher's analysis in Quadra, I referred the court to page 380, rights can be insurable interests, such as, for example, the immediate right to possession. We say, lastly, on this, that there are very well-known forms of words that have the effect for which the respondents contend. If the insurer had meant to restrict the extent of cover to what is required under an underlying contract, they could have said, to the extent required under an underlying contract. That would have achieved that effect. If you go, and I won't ask you to go to it now, but we saw it this morning, at page 85 of the authorities bundle, within Petrofina, we have an example of a clause, a very well-known, very frequently used clause called the contrary provisions clause, which has that effect. The clause says, assured, save to the extent there are provisions to the contrary in specific contracts. That's what we saw it.
So you say right in this case would not include the right that Conway had for the option C insurance?
No, my lord, it just doesn't refer to that. All that is referring to...
So it's a restricted use of the word rights?
It is... I would
It's a
say...
matter of law?
I would say not a restricted use of the word rights, an expansive use of the word rights. It is saying that Conway is insured for all of their rights and interests.
Why can't they include rights under a contract?
I'm sorry, my lord?
Why can't they refer to contractual rights?
So
If it doesn't, then it is Milord's right. It's restricted.
So it's not restricting to contractual rights. It could include contractual rights.
That's the point. If it could include contractual rights, then why doesn't it?
Well, we say it can include any rights.
Yeah.
But it's saying for all your rights and interests. What it's saying is that Conway is insured for every insurable interest that it may have.
Each for their respective rights and interests.
Those are not words that are cutting down the extent. They're not circumscribing the extent of Conway's cover. But they are doing, as the authorities say, that they are saying Conway is insured for all of their insurable interests, which may include rights, such as the right to possession, and they are insured as if they had taken out.
It
their
may
own
include
policy.
contractual rights.
It may include contractual rights, yes.
I mean, I don't want to get into trouble by referring to another authority, Mr. Gladdy, but I noticed from McGilvery, page 412 in the authorities bundle, the authority for the proposition that it is usual to describe the co-insureds in a composite policy as being insured for their respective rights and interests is general accident.
Yes.
Green MR,
Yes.
and I've just got page 19 in the authorities bundle, where that seems to be where the late Master of the Rolls deals with this. And he says at line 4 of page 19, the description of the insured by name followed by the words for their respective rights and interests, in my judgment, read in its natural sense, read in its natural sense, indicates that these three persons having interest which is not material to investigate for the purpose of the document are minded to combine in one policy, and each of them to obtain cover for the underwriter's respect of his right or interest, whatever it may be, and may vary from time to time.
Yes.
I mean, that's a quick. That doesn't seem to be a restrictive use of the.
No.
It seems rather to be
Expansive.
not expansive, but just in its natural sense.
That,
But that's just a quick reference. So I'm sure I'm being superficial.
no, my lord, that's our point. That is what we say it means. It means all their rights. they're insured in respect of all of their rights and interests. Whatever insurable interests that they may have, they are insured in respect of it. And again, if I may, we don't read it, just finally on this, we don't read it disjunctively from what the insurance is. So the insured, it's telling you, section 1, the insured is insured in respect of the contract works for their respective rights and interests. So they are insured for their respective rights and interests in the contract works. That's what this means. Whatever...
Sorry, the insured...
Yes.
Those are individual legal people from A to G.
Yes.
And then the qualification to that, if it is a qualification, is that each of those legal people from A to G is part of the definition of insured, each for their respective rights and interests.
Each for their respective rights and interests in each section of in what's covered by each section of the policy. So if we're talking about section 1, they're each insured for their respective rights and interests in the contract works. That's what's covered by section 1.
Well, you tell. Well, anyway, okay, I understand that.
And,
all right. Is there anything else?
There's nothing else save to say that question, the insurable interest, is also analysed in National Oil Well, where Mr. Justice Coleman concludes, and Lord, he concludes that a subcontractor has a pervasive insurable interest in the whole of the works, that even postdates his participation in the works. He can insure the whole of the works in his name, recover, and then hold that on trust. And that's a conclusion that Lord Justice Dyson endorses in Feasy and Son Life many years later. But you read those words by reference to the specific section. Section 1, contract works, Rugby Football Union is insured.
I think I'm going to have to gong you off,
Yeah.
Mr. Garner. You're repeating yourself, and you've had more time, I think.
Thank you, my lord.
Yeah. Okay. Yes, Mr. Reed.
My lord, if I could briefly, before I go into the main body of my submissions, just draw your attention to one or 2 points. Firstly, if we can go back to the letter of intent, please, at 225. Yes, it starts at 225. Draw to my lady and my lordship's attention to the fact that in paragraph 2, there is a reference to a document ID at 225. I think it actually is paragraph 3. And that reference was in the trial bundle to a contract that contained the material form of the insurance, i.e. option C.
Yes, I see. So the document.
In other words, this letter of intent, and if I may call it a contract, because that's, as I read it, how it was treated, included reference to a specific document.
Specific document, not just a form.
Correct. Secondly, if I can draw your attention to page 228 and clause 21, which I would describe as an entire agreement clause, and effectively prohibits reference to previous communications. The next point is to briefly look at the judgment in my bundle behind divider 5, starting at page 55, and to pick up one further reference at the very bottom of page 81, paragraph 125, which also goes to findings of fact.
So this is judgment.
Page 81, paragraph 125.
Thank you very much.
At the bottom it says, I am satisfied that the understanding which Mr. Higgs had of the effect of the policy did not accurately reflect the terms on which the RFU and Conway were dealing, nor the basis upon which the policy was taken out. So when it's said in submission that findings of fact were made upon which they rely, it has to be seen in the totality. In other words, all the provisions. Effectively, when I say effectively, this judge was very precise in his language. Paragraph 106 on page 78.
Hang on, I'm just making a note of.
Seeking to gain momentum.
No. Yeah, okay, so that's the 125 point. Which
Yes,
is the
I'm
next one?
just joining the threads together now.
Yeah, no,
Paragraph 106, page 78, and to look at the totality of the findings of fact. And the first point is the judge of first instance was careful to use the words in paragraph 106. They both believe, in line 2, they were giving evidence before me, they both believe that the intention in 2012 had been for comprehensive insurance cover. And the key here is the judge was making findings. They are findings of fact as to their individual intentions. But one of the flaws in the arguments that's put forward by Conway is the failure to distinguish between the entities and the individuals. And the individuals have discussions which the learned judge was addressing. But what really mattered, as he makes clear in the subsequent paragraphs, that their understanding, for it to have any contractual relevance at all, be in terms of authority and intention, has to be on behalf of their relevant entity. And that's where he comes to paragraph 108. And that is what he is dealing with in that last sentence when he's talking about the contractually effective dealings. Now again, those words are precise. They are not limited to the terms of the contract. He's dealing with the course of the relevant dealings, including such things as authority. And one can see he uses the word basis, so the basis of the agreement and so forth, when one goes through this judgment. And the reason for that is this, that I won't say in every case, but in almost every case, when one is looking at authority and intention, they can be found in one place. The contract gives you the authority and the contract gives you the intention. It's not to say that Mr. Garley is wrong on his principles of law, although I will come to that. But as a matter of practical reality, they're almost always found in the same place. It would be most odd if one engaged respective firms of solicitors, project managers and so forth to enter into negotiations to find that the obligations in the contract weren't all the obligations and all the authority and all the intention. It's not that it couldn't be, but it would be highly unusual.
Well, there were 22 contractors in this case.
Well, there were, but in a sense that point is still made good for each one.
Yes.
One
right.
looks to each contract.
Yeah, I see.
And the reality is, particularly when dealing with letters of intent, the contractors are not always continued to be engaged. And when Mr. Garley talks about, well, once you look at the face of the policy, effectively, that is it. That doesn't really begin to engage with the ordinary and natural course of construction projects. And I'm not going to take your lordships to it, but paragraph 16 of Mr. Justice Fraser in Haberdashers gave a useful summary of the background to these types of policies in the construction context. And whilst this is not an example, one can see the example of a different contractor being appointed and the letter of intent being terminated. The reason that's important is because when one's looking at the definition of a term in a policy where it says contractor, it's wholly wrong to submit, so we would say, that the A701 works necessarily always means Conway. Of course it doesn't. A different contract may be substituted for the same works. And the reason that is important is because it helps one understand, again, we would respectfully submit, the fallacy that Conway are identified by description. They are not. It's happenstance that they are the contractor of those works. The true test when looking at whether something is identified is, in a sense, to provide the policy to someone else and ask them, who is that? And if they have to look further to other documents, that tells you the description means the party is either capable of being identified, or if they're, in the rare case the description is so obscure, not capable of being identified at all. The next point.
So on your submissions, they were what? In
They
this
were
case?
capable of being identified.
Identifiable.
Identifiable by reference to, as we would say, the building contract. On all routes in this case, all lead back to the building contract.
So, sorry, so they're identifiable. What was your point in relation to the building contract?
They're through the building contract because I can again take you to, the policy refers to the A701 works.
Yeah.
You look at the works, you find the contract, you find who the contractor is. Then you find the extent of their cover. Now again, dealing with some of the policies, when one is looking at authority, there's a good reason why when you're identified you don't need to look at intention. That's because the person's identified. It's there, you can see it. That's why there are not copious authorities on it. What that doesn't mean, which is at the root of Mr. Carley's submissions, is that one doesn't have to look to the scope of that authority. And the scope of that authority, again, takes you back to the building contract. So, when you heard Mr. Garley's submissions in his skeleton argument, it's actually sometimes difficult to work out what the guiding principles are and how they're to be applied. So what I now intend to do is set out what I consider to be his case, and what we say are the three questions you have to answer, and what we say about them.
So these are the principles, are they?
Yes, I'm just, by way of saying, right at the beginning, summarising, but first we have to identify what the basis of the appeal is. And step one is that Conway say that the judge made an error of law in this case, and it's said to be his interpretation and application of Garde Marie.
Yeah.
And I have to deal with that. Secondly, they say he should have asked what the authority was of the Rugby Football Union, firstly as a disclosed principle, and alternatively, what was the authority and the intention of the Rugby Football Union was as an undisclosed principle. Next, they say if the judge had done so, he would have found authority in the communications of Mr. Higgs and Mr. Morris in the start-up meeting, the absence of anything in its tender, and that it didn't procure the relevant form of insurance. And accordingly, they say that Lee would have led the judge on these findings of fact to say they are fully covered to the extent of the policy. And from those, what we say are 4 core building blocks of the appellant's case, derive 3 questions. The first is, Was the judge at first instance correct in his application and interpretation of paragraph 139 of Lord Coulson's dictum in Gardnery? Now we say he was correct about that, and I'm going to make some submissions on that. And if we're right about that, the key point is that grounds 1 to 4 fail. The second question is if the
and when you deal with that, you'll tell us why 1 to 4 fail.
Yes,
If you're right.
because I say that's the gateway.
Yeah, I understand that, but the detail of why that's the
I'm going
gateway
to come back
for each
in.
of those you'll come back to. Now,
If permitted, I will
Yeah.
I will explain in
Fine.
substantial detail
Yeah,
on each one of these points, but I'm also prepared to do it in summary.
yeah, that's very helpful.
Insufficient time.
Yeah,
The second question, but I just in a moment outline where I'm going,
yeah,
is if the judge's interpretation of Lord Coulson in Gardnery was incorrect, you have to ask yourself the question, what does that mean? And I am going to slightly diverge here to go into a little more detail before I go to question 3. Because question 3 is ground 5 and the waiver. Conway say in their skeleton argument that the judge should have asked himself whether Conway had authorised the Rugby Football Union to procure insurance that could cover the loss in question. And on an alternative case, that the additional question of whether the Rugby Football Union had told Conway that it intended to procure such insurance. And that's their paragraph 42 of their skeleton argument.
yeah.
In seeking to answer that question, or more materially to criticise the answers the judge gave, Conway relies upon discussions between 2 witnesses. That's Mr. Higgs and Mr. Morris. But of course, this comes back to my point, that the question is about not the individuals, but the entities concerned. It's not the authority or intention of 2 specific individuals. The relevant question is what authority or intention did the Rugby Football Union have at the entity level? Now, as to authority, there are numerous authorities that all make the same point. We say that the strong presumption is that that is to be found in the underlying contract. And we say, in this case, it was the letter of intent. And for that, may I just, again, slightly digress to go to the core bundle between Divide and 9, at page 128, which is Conway's defence. And the 2 paragraphs to bear in mind are 30 and 31. And that's because their case for the preliminary issue was that the contract was on the terms of the letter of intent and incorporated such parts of the intended contract terms as were relevant to the work specified in the letter of intent, together with the email of 2nd of July. And in paragraph 31 over the page, on page 129, also importantly, the terms and conditions of the JCT contract were identical to the intended contract terms as varied, save for minor differences which are immaterial for the purpose of this claim. So, as to authority, I've mentioned a strong presumption. I've identified where, if I may put it this way, is common ground, what the contract was, the date of the contract, and in what form it came. I've made the point to you that in most cases, and in this case, authority and intention arise out of the same evidence. And in this case, we say the contract. And that's important because when considering whether this learned judge was erred in the way he analysed it, you will no doubt have in your minds that he did exactly what Mr. Garley said should be done. He went back and he considered from the very earliest meeting between Mr. Morris and Mr. Higgs, right the way through to when the October contract was signed. He looked at the totality of the evidence before making findings of fact. He cannot reasonably be criticised for not addressing his mind to the correct contractual issues. And at its heart, Conway has to overcome the findings of fact. The findings of fact taken in their totality, including the fact that he was not persuaded that Mr. Higgs' view of the insurance cover that was going to be procured was in fact correct. Now, as to intention, the Rugby Football Union says this does not arise where an agent discloses that it's acting for the principal. The reason, as I said in summary in answer, it doesn't arise is because if it's all disclosed, intention in practical reality becomes redundant. And in this case, the identity of the putative principal, Conway, is not an issue. This is because it's common ground that the Rugby Football Union did, when taking out the policy, intend to cover Conway. That is not the question. You have heard lengthy submissions about the law about authority and intention. And one of the questions you will have to ask at the end of this is what turns on it? Nothing turns on it. The question is as to the extent of Conway's cover under the policy. And National Oil, which I'm going to go back to under the relevant ground of appeal, establishes that authority and intention are relevant when determining the extent of the cover. And that analysis is followed and adopted in Coulson. And one must therefore focus, because one can have very interesting debates in what is a difficult area of the law, where some issues are still in flux. But that is not this case. In this case, it's about the extent of the cover applying agency principles. Now, as for the factual findings, of course, adopting in a sense approach that's been adopted this morning, which is to say, look at what Conway have to themselves establish to succeed on the appeal. They have to establish that Mr. Higgs and Mr. Morris represented the relevant authority at the relevant time as given by Conway to Conway and the RFU's authority. So their respective positions at the relevant time. As I said, by way of a thumbnail sketch at the beginning, the court reviewed the understanding of those individuals, but found rather differently when it came to determining the terms of the contract and authority and intention, paragraph 108 and paragraph 107. The finding of paragraph 108 was not the understanding of Mr. Higgs and Mr. Morris at the pre-tender meeting. The difficulty with Conway's submissions, as I would respectfully say, is it tries to create a bright line between the earlier discussion, which they treat as authority, the Higgs-Morris discussion, and the subsequent discussions between the professional teams when concluding the contract. And that simply is unrealistic in a construction context. what happens is it's a continuing discussion. Typically, and I'm sure the court will accept this, at the pre-tender stage, there are high-level discussions about the works, about the form of the contract, and so forth. Just as this learned judge found. Discussions with more than one party. The nitty-gritty of the discussions dealing with authority, the form of insurance, the type of insurance and the extent of insurance, together with a myriad of other issues, are all done by those professional teams. And that's what the learned judge was addressing his mind to in paragraph 108. Materially, the question of insurance was in the hands of Mr. Pettifer. And that, of course, was their evidence at trial, not the evidence of the RFU. And the problem Conway have, amongst many, is the court considered in detail the discussions between Mr. Higgs and Mr. Morris and made a specific finding of factors to their understanding. But it wasn't the basis, as he found, upon which the actual agreement itself, subsequent concluding negotiations, were found. Paragraph 125, last sentence. Mr. Garley developed a submission with reference to paragraph 108. If my lord or lady want me to take you to the paragraphs, it's just that I know that if you've seen them once, you may not want to go back.
You're saying it was the last sentence of it?
Yes, I'm doing that from record.
No, just so we can mark it.
Yes. Yes, I'm satisfied that the understanding...
His finding that the understanding was not the basis of either the contract or the policy.
Yes.
Yeah.
So the fact that he found them to be patently honest and careful
Yes.
had no ultimate bearing on his decision on this point.
Because the evidence was honest, correct, reliable, but ultimately it was one small step in a chain. And I was going to describe that in my next point as the continuum. Because, as I said, it's not a bright line between that discussion and the subsequent discussions which led to the contract. What happened is, as one would expect, teams come on board. On the part of Conway, they have their, he referred to, they have a separate insurance manager. The Rugby Football Union used external well-known solicitors. And there were various other parties. And it's between those groups of people that what happened was it's not reasonably arguable to suggest that, say, Forsters on behalf of the Rugby Football Union didn't have the requisite authority. And to take an example, it's not reasonably arguable to say the representatives during those discussions on behalf of Conway, at that time, they didn't have authority. Of course they did. And I don't actually understand it being said in black and white terms that they didn't. And if one accepts that proposition, then one is in grave difficulty, because the only way in which the appellant can succeed is to suggest that the earlier discussion between Higgs and Morris is somehow cast in stone, doesn't change. And of course, authority can change. Intention can change, and it can change all the way up to the point of the contract. And that's why, this learned judge, he used the words in paragraph 108, contractually effective discussions. He's not suggesting for 1 minute there weren't discussions. What he's saying by that is the ones that are relevant, led to the contract. The important ones are dealt with between the teams.
Yeah, he doesn't say in terms that the discussions between Mr. Higgs and Mr. Morris were not part of the contractually defective dealing.
No,
but he says they weren't principally.
Of course, and one can understand that. If one takes the logic of it, there's a discussion that starts at point A and it ends up at point X and in between there's discussions that go forward. It's moved between people. Other people come on board. And our point is you can't separate that. You have to look at the totality. And that's what this learned judge did. And then he found it should come as no surprise when the big teams get together and start discussing. That was what was contractually effective.
Well, the judge really captures it, doesn't he, at 108, where he says that the parties were substantial entities dealing at arm's length. There was a major exercise, and that is why one might say sensibly teams were instructed for a specific purpose.
Indeed, the background to this, of course, is the Rugby World Cup. They were reinforcing their services to make sure there wasn't a problem. And there were 22 odd, probably more contracts. This was a major enterprise. So it's my respectful submission on looking at this point that the judge used his words carefully on every occasion to reflect the true position. And the true position is that by the time the agreement was reached, the true authority given to the Rugby Football Union at entity level wasn't that came from Mr. Morris. It arose out of the discussions that led to the contract. And we make the point, again, that it's the contract in 99% of cases which he identifies both authority and intention. And the finding that at paragraph 125 is consistent with that in relation to Mr. Higgs, and that is not something which has been the subject of an appeal. Now, if the appellant wanted to make a submission about the failure to attribute knowledge from Mr. Higgs and or Mr. Morris or Mr. Higgs to their respective principals at the relevant time, that would have had to be a separate ground of appeal. There is no such ground of appeal. And so, in a sense, those are my overriding observations in respect of the second question. The third question is, does Conway benefit from the waiver of subrogation? And when one delves deeply into certain authorities but not others, one fails to have what I would describe as the stand-back approach. And say, if there is a complete waiver of subrogation, why would any insurer waive its rights to subrogate in respect of uninsured losses? In other words, if there's a complete waiver against everything. And that's not my point, that's a point made by Mr. Justice Coleman in National Oil. So we stand behind the judge's findings on his interpretation, but again we make our points, which we made at first instance, that the interpretation of an insurance policy is always going to be determined by its terms and by the factual matrix. And there is no one hard and fast rule for every case. And
is this right, just so that I'm clear, on this point, which is ground 5, the judge's, the way in which he arrived at the answer wasn't actually what anybody had argued?
Correct.
So you say you stand behind his interpretation, but you also repeat the submissions
yes, because
made below.
We made a completely different point, which is in fact not articulated really in the judgment, which is the point with general accident of saying rights and interests naturally, using the natural words. Interest is insurable interest we accept. Rights include the right to insurance under the building contract, and you go back to the building contract, and to the extent that you have that, that's one of your rights, one of the things you enjoy. So
I see. So when the judge on this basis went slightly off piste for the ground 5 point, what he was veering away from was the rights and interests point.
well, he seems to, but it's not difficult. It's difficult quite to know why, because he actually says within the judgment that he thought those submissions were right, but he just never mentioned what the submissions were, or why he thought they were right. And so, emboldened by that, I repeat the submissions before this court.
Okay.
But
This is a sort of invitation for a respondent's notice, isn't it?
Yeah. Yes.
well, it would have obviously been preferable had
Well, these
he
things
reviewed it,
these
but-
things happen, and you know we're here to try and assist. But
Yes.
but that I just wanted to, because I'd seen some debate about whether this had actually ever been articulated,
No,
and
I think
that's
we all accept
effectively
it.
the position of it.
We had the debate before the learned judge, and he decided to approach it a different way,
Yeah.
but while saying he saw the force in those submissions.
Yeah. Okay.
Okay, so framing the issues, the whole of what the primary issue is about, is whether the insured losses of £3.5 million are irrecoverable from Conway. And the learned judge obviously found they were recoverable, and that takes us straight into ground one.
Can I ask this just as a procedural point for the background to the preliminary issues? Was this on the assumption that the pleaded claim was correct? I mean, so that I mean,
There are no findings, substantive findings of fact as to whether
No.
any facts or even quantum, in a sense, it was all an issue.
Yeah.
It was just because this was considered to be a sudden death point.
yeah. So the underlying allegation made by the RFU against Conway is that this damage and therefore this loss was Conway's, or arguably
Or
CSP's responsibility under their respective contract.
Correct. The premise of ground one is that on a correct application of the law to the judge's findings of fact, Conway had established it was co-insured with respect, in respect of the relevant losses. We submit it that way because there has been a disconnect in the submissions between the points of law made and where they go. And it's not just that the judge might have got the law wrong, but it has some material difference in this case. And there are two parts to ground one. The first is a proposition of law that Lord Coulson, as I said, was wrong in Guard Marine. And secondly, that the judge's findings of fact, when the law is correctly applied, lead only to Conway being insured for the relevant losses. Conway required both parts of those to be made out to succeed. Now, dealing with part one, which is Guard Marine, one has to, I think, start at the starting point, which is the meaning of composite insurance. And that's just a method by which, for convenience, more than one party can participate in insurance. And perhaps not the legal way to describe it, but the sensible way to describe it is to say each insured is treated as if they have their own policy. So they may all be named, but that's just for convenience. The second point, by way of background, is there are obviously different means of participating in a construction all risks insurance policy. And that will depend on the circumstances of the parties involved and whether one can identify the insured at the date of the policy. Now, the judge understood that. And if I can just take you to through the logic, paragraph 50, page yes, page 66 of the core bundle of paragraph 52. Not surprisingly, the first sentence sets out the core starting point. In addressing the primary issue is the principle that law does not allow an action between two or more persons who are insured under the same policy against the same risk. Now, you've heard extensive submissions that the judge got it wrong because he was looking at effectively whether claims over could be recovered and so forth, and referred to Guard Marine in the wrong context. But it's plain from the very first sentence, where under the heading which is important, the approach to be taken as a matter of law, he identifies the first of the principles, citing Lord Hope in CRS, who also CRS then went back to Petrofina. At paragraph 124, he correctly identifies the point, which is firstly the nature of the loss, and was the RFU intending to take out insurance cover covering Conway in respect of the liability for such loss? And the key words here again, which they get lost because these words are important, with the consequence that RFU's recourse should be limited to a claim under the policy. This area of law is sometimes bedeviled by people summarising. And when one talks about a fund, sometimes one is often talking about the insurance being the fund and nothing more. And here you can see the learned judge understood that because it's the consequence of co-insurance in respect of liability that recourse should be limited to a claim under the policy. No more. Now the judge correctly concluded so I'm just, because I've altered my numbering slightly because there are two numberings for the bundles. Yes, so he understood the two different methods. It's at page 70. Just want to make sure I've got the right reference. If I can come back to the reference in a minute when I find it, but it's uncontentious that he understood that the two methods of participation were either agency or standing offer. Agency, National Oil Well, application of it, the judgment of Mr. Justice Coleman. Standing offer was the application of Mr. Justice Fraser's decision in Haberdashers. And that leads us, therefore, into Guard Marine. Now, it's important to understand that you were taken to paragraphs 99 and 100 of the speech of Lord Sumption in Guard Marine. But he was in the minority when deciding, or when separating out two questions. And it's not that he was wrong, or we would submit he's wrong in separating it out. But it's important to understand that there are 2 points at play within that decision. The first of which is the effect of co-insurance, and the second of which is whether liability was excluded or the insurance discharged the liability, and that was for the purpose of pursuing claims over. Now, the entire thrust of Conway's submission is in respect of the second point in their skeleton argument. And that's where they refer to Lord Coulson and say that Lord Coulson, paragraph 139, referred to the fund. That was to the second point, and that was not an issue in this case.
Yeah.
But Lord Coulson was actually referring to it, and I'm going to take you in a minute to Scottish and Southern Octave, which summarised the points in Garde Marie. But the critical question which he identifies and formulates really goes to the fundamental issue of whether there is co-insurance. Now, to know whether there's co-insurance, you have to look at the contract, because you have to look at the extent of the agreement to provide cover. And that didn't limit or address, or otherwise deal with Lord Sumption's second question. And so I'm going to head into the authorities to make that good. I am working, I'm afraid I haven't had time to renumber this bundle, because I am running from the Opus bundle, so I'm hoping my junior will pipe out with the relevant numbers as I go through. It's at G12.
Hang on a minute. What are we looking at?
Which authority?
Scottish and Southern, SSE Generation and Hoxton. And I think Lord Justice Coulson probably has come across this case before, or at least may have had it cited. It's a construction case.
I'm always nervous when people make that submission, Mr. Reader, as you well know. It's not one of mine, is it?
It's not.
No.
Because
Well, that's a start.
Safely, it's in
Then I'm
the
forgiven
session.
for not necessarily remembering it.
It's just that it's often cited, but perhaps for different reasons. And it's just a construction case about a hydroelectric scheme where there's partial collapse, and the question was under the contract whether it's due to defect in design or construction. But the key question we're looking at here is whether there was an all-risk policy, co-insurance, and whether it was effective. And it's an extremely long decision, and I'm going to go to using the internal numbering at the top 641, internal numbering for Opus G/12.
Well, let's stick to the numbering in the top right.
Do forgive me, overnight I will renumber.
No, don't worry, don't worry.
And it's the decision of Lord Glennie, which is in column 2.
So you're taking us to internal page
339, I'm told, is your bundle reference.
339.
Yes.
Thank you. Yeah, Lord Glennie.
And it's just here. I don't intend to read from this, but just to point on the first column, you can see that the other members of the court agreed with what he says. If you can see underneath B. Yeah.
Yeah.
And then I want to go on to the substance of what he says, page 648, pick it up, paragraph 398.
That's 346 in the bundle.
Thank you. Column 2.
Sorry, paragraph which?
398 at the
Thank you.
column 2 at the bottom. The ocean victory is another, is what they describe Garde Marie. And they just, I pick it up there, but I'm not going to read out, because over the next page, at C in column 1, says, he then goes on to explain what Garde Marie decided. And he categorised the question whether the contractual scheme precluded a claim for the insured loss as one of construction. He continued, the question in each case is whether the parties are to be taken to an intended insurance fund, which would be the sole avenue for making good the relevant loss, and so forth. In other words, in exactly the same quotations, he relied page 1839, paragraph 40, upon the decision in CRS. Then goes the next paragraph, as one goes through, you can see Lord Coulson approved the reasoning of Mr. Recorder Jackson. And the key point here, which I can take relatively shortly, is in column 2, paragraph 402, he takes the point about by Lord Sumption as a different and separate point. So,
Yeah.
yes, do forgive me the relevant words because I'm speeding up, is on the next page, paragraph 404. I should mention at this point that Lord Sumption went on to raise a different question directed to identifying. So forgive me for that. I'm not going to go through it because it makes the point that we make rather better, that in fact the reference by the learned judge in this case to the relevant paragraph was the correct paragraph to consider. It was the one that was considered in Scottish and Southern, and the reason it's the correct paragraph is because we say that Conway have misinterpreted Gargmarine, paragraph 139, which is a general statement of principle, and Lord Sumption, who was in the minority in paragraphs 99 and 100, dealt with a different and separate point, and to align the two is an error. So, if that's right, do forgive me, does one have to finish at 4 o'clock today?
Well, when you get to a convenient moment, so if you're finishing off on this, carry on until you finish that point, and then we'll...
Quite a bit more to do on this, and I don't
Oh,
want
have
to
you?
delay.
Oh, well, if you have got a bit more to do, then we will pause there. So
I'm going to try and speed up tomorrow to go.
No, don't worry. I think if you can cut your cloth,
Yes.
I think that I'm assuming, as I said earlier, and nobody dissented, that you're doing the bulk of the respondent work. That's not to say that Mr. Weiss isn't entitled to make submissions, but I would like you to operate on the basis that you have to be finished by lunchtime at the latest, and so there's then Mr. Wheater and Mr. Garley in reply. Okay, and if somebody could provide perhaps the judicial assistants with copies of Volker Trek, whatever it's called.
Volker Fitzpatrick and Twin Tail.
Yeah, that's the one, which was also relevant on, anyway. If you could provide them they can provide them to us.
Well, we have that here sidelined, we will provide it. The other question is whether it would be helpful and permissible for someone to sideline your bundles overnight.
No, not now, because we've marked them up, so I'm afraid that horse has bolted. Fine, all right, well, unless anybody tells me to the contrary, any of you tell me to the contrary, we'll start again at 10:30. Okay, 10:30.